Welcome back to Defending the Windy City with attorney David Drwencke. David is the founding partner of DRD Law, where he focuses exclusively on criminal defense in Chicago and throughout Cook County. Known for his courtroom strength and procedural precision, David helps clients rebuild their lives long after the verdict. I'm Leanne Lyon, and today we are talking about how Illinois handles record clearing from expungement to sealing and what it really takes to get a second chance. David, what's the practical difference between expungement and sealing under Illinois law?
Sure. Well, good to be back. I love talking about this topic because it's more positive than what we do on a day-to-day basis because we're talking about getting something off someone's record. And you've already hit the nail on the head. In Illinois, there are really two options. There's expungement and then sealing. And in many respects, you end up in the same place. It can have the same practical effect for my client, but they are different. Expungement is effectively doing away with all of the records. That the fact that there was a police record, there was something at the clerk's office, it was something somebody may be able to go in and do a search through what we'll call the Odyssey portal or the clerk's portal, that you could look it up and say, oh, there was a charge for John Doe. That goes away. It's deleted. If an employer or perhaps you're applying for school or a loan or trying to get a new lease or a mortgage sometimes, all of those background checks, the record will no longer appear with an expungement because they're gone. No one can go and get those records. Whereas a sealing still has many of the same effects, but those records still exist in certain entities, perhaps the police or a prosecutor's office or even the clerk's office under certain circumstances. They exist. They're hidden. Not everybody has access to them. It's as if they don't exist for many other outside entities, but for police, law enforcement, uh, other entities, they still exist and under some circumstances could be reopened or used to be held against you with a future criminal case or something like that. So expungement and sealing, practically speaking, for my clients are the same, but in reality, there is a difference, and we're usually trying to get an expungement to do away with all of those records so they'll never come back to bite you. No one has access to them. Nobody can use them against you in the future.
So, who qualifies then to have a record expungement, and how far back can somebody go?
Well, and that's really the ultimate question when it comes to eligibility is, well, who is eligible? How do you become eligible? And then whether or not will it be granted? So the first question is, am I eligible? And that is case by case specific because we need to go and look at, well, what were you charged with? What were you ultimately either convicted of or what did you plead to? When did that happen? And those usually can answer the question. Is it old enough? Meaning you took the plea or you were found guilty long enough ago in the past that you've become eligible. And then the other portion of it, well, that what did you plead guilty to? What were you convicted of? Because there are offenses that unfortunately are not expungible, are not sealable just by statute. So it could be 20 years old and you could have nothing else on your background, but that specific offense has dictated that it is not something you can go and seek to have expunged or sealed off of your record, unfortunately. Now, of course, there are plenty of other things that you are eligible to have expunged and sealed, but we need to get into the weeds and know exactly what it is. As far as time frames, typically we're talking 2 to 5 years after you're done with your sentence. And so what does that mean? This is where some people can kind of get lost in the weeds is, well, I pled guilty in 2023. We just closed out 2025 heading into 2026. Like, it's been 2 years. Can I get my record expunged? It's like, well, when did you plead? And then when does your sentence end? Did you get a time considered served and you were done in 2023? Or did you accept a probation or some sort of jail time that didn't end until 2024 or perhaps 2025? Because it's 2 years or 5 years past the end of that disposition. and the sentence, disposition being the plea or the conviction, and then the actual sentence. The sentence is oftentimes what will push things down the road and means you have to wait a little bit longer, unfortunately.
Have there been some recent changes to Illinois law which affect what can and cannot be cleared?
There have been. There's been a lot. In fact, there was a law that was just signed to go into effect here in 2026, which is expunging a lot of records, even without defendants having to go through the legal process of filing a motion and paying an attorney and going through the rigmarole that is an expungement or sealing process. And it's very well intended. It's a number of people who have low level offenses that maybe they didn't even know that expungement or sealing was an option, and or they didn't have the money or the wherewithal to go through the process. Not that it's overly complicated, but it's just difficult enough that if you've never had to deal with the court system, if paperwork really isn't your forte, or you don't know all the details of your case and where to look them up, it's like, where do I even start? How do I file this petition? What else do I need to file? Who do I have to inform? That's it, is what makes it more complicated, not difficult. It's the rigmarole. But that the new law that was signed by our governor, it's applicable obviously throughout the entire state of Illinois, is making a number of offenses instantly expungible or sealable, and they're just kind of doing it for people at this point. All the types of cases that are included in that, I'm not quite certain, because the law itself now is merely only a couple of days old. But I'm excited about that because it's clearing records for people without them having to jump through hoops, which is a good thing.
Well, I hope they're being notified so they know.
Well, that's just it. Is it's interesting in kind of the practical reality. It's like, well, how are they going to do this? And somebody who might, at least they know they have a background or they know they have a record. Well, now it's been expunged. Now, do they know it's been expunged or that they're eligible for it? That becomes one of the big questions about how is this going to work in reality for a lot of people. That I'm not certain of, because it's brand new. But again, I'd rather people find out as a happy circumstance that it's like they think they have to disclose something, but come to find out you run a criminal background check, it's no longer there. It's off because they've been welcomed into this system. That's great.
Best kind of surprise, absolutely.
That's
But
right.
what kind of cases are ineligible no matter how much time has passed?
Well, there's a lot, and they're typically violent offenses. But the one that I think is worth calling out, because we run into it so often, and it's a misdemeanor that it usually surprises people, is that domestic violence, the run of the mill common domestic violence in Illinois, is what's called a Class A misdemeanor. So it's punishable up to 364 days in jail, like on the high end, if you were to actually be convicted and sentenced to the high end. But it's a misdemeanor. So many people would just assume, yeah, it's a misdemeanor. Aren't all misdemeanors automatically expungible or sealable? The answer is no, it is not. So that surprises a lot of people, and that's one of the big key things that I and my associates, our firm, look at when we're handling a case like that, is to properly inform the client that no, I don't believe you're going to go to trial, or go to trial and be convicted and go to jail on this. No, this isn't a felony. Like, take a deep breath. It's not as serious as maybe you originally thought it was, but this can be on your background for the rest of your life if you are convicted, or if you do plead guilty as charged. If we can't work something out, probably the most common example of that is working out a plea agreement where we amend the charge from domestic battery to just battery. A simple battery is expungible, whereas a domestic battery is not. And that is a very subtle difference, but it makes all the difference for a client about trying to clean their record in the long term. Other examples that come up are a lot of violent offenses are not expungible. So if we're talking about aggravated batteries, batteries to police officers, things involving weapons and so forth, more often than not cannot be expungible. There can be some limited examples where it might be sealable, where for the practical reality of my client, they don't have a criminal background that somebody's going to find through an employment search. But if they ever wanted to renew a FOID card and be able to legally possess and purchase weapons, probably never going to be able to do that again, or it will be such a long time down the future that they'll ever be able to legally possess and own a gun, that that's going to be an issue because the Illinois State Police, the state's attorney for whatever jurisdiction you might reside in, Cook County's home base for us, but anywhere else in Illinois, they will still have a record, even though it's sealed, of a conviction that might involve violence or illegal possession of a gun, or if it wasn't illegally possessed, it wasn't transported correctly. Those types of things will always come up to bar you from being able to get a FOID card. So that's where that difference in sealing and expunging can matter a great deal, as it affects some of your other constitutional rights. But the big kind of broad strokes of things is more serious felonies and then violence offenses, and those with guns probably won't be expungible, but you'd want to contact the firm, contact an attorney who handles expungements and sealing to know about your specific situation, about whether the offense you're trying to seal or expunge is eligible. And if you meet the other criteria, like we talked about earlier, is that offense might be sealable and expungible, but it is not yet ripe to be expunged or sealed.
So, how does the process start? Where do people file and what documents are required?
It's pretty consistent county to county, but I'll use Cook again as probably the best example because that's where we do most of our work. Is there's a petition to expunge or to seal that you have to complete, and there it's, I believe, 5 pages long, and it looks more daunting than perhaps it really is. There's a number of blanks that need to be filled in. Most of that information you can provide on your own. It's biographical information. You know, what's your height, weight, sex, date of birth, what's your address, and so forth. You could complete that basic information. Where it can get a little more complicated is if you don't have your case information. So you'll want a case number. What was the charge you ultimately pled guilty to or you were found guilty of? What was the where did that happen? What courthouse and courtroom and so forth? Who was the arresting agency, which can be very tricky for people, where they'll know, hey, I went to this courthouse, I even have the case number, but who arrested me for this? I have no idea what jurisdiction it was. And why does that matter? We'll get to the next portion of this, but you'll complete the petition. Is it just this one case, or perhaps you have multiple previous convictions you're trying to seal or expunge? Complete the form. That's the petition, the actual ask. I am asking that this case record or these case numbers be expunged or sealed. Next is notice. You actually have to go and notify a number of entities. One is the state's attorney's office, which kind of makes sense. It's the representation of the people of Illinois. So the Cook County State's Attorney's Office. You have to inform them that you're trying to have this sealed because they get to respond to this motion. The other, which goes back to the petition, is you actually inform the state police agency or the county police agency or the sheriff's department that arrested you, saying, I am seeking an expungement and a sealing of records you have. So I'm going to put you on notice that I'm trying to have these records sealed or expunged. That's why you need to know what entity or jurisdiction arrested you, because you have to inform them. And then, of course, you have to notify the court saying, listen, I want to be on your docket. I want to be in front of a judge to have this heard and to be granted or denied, which then leads to the last portion is you provide both a blank order with you have to fill in some basic details, but this order granting the expungement or sealing, and then a blank order denying the sealing or expungement. And then you'll, assuming you've completed all the correct hoops, you've paid the fee associated with filing the information, you'll get a court date. In Cook County, I can say pretty consistently it's a good 90 days or more out. So it is not a fast process. And all those entities will be notified. They will have an opportunity to submit a response or an objection to your request for expungement and sealing. And then you appear in court. Again, in Cook, they're oftentimes allowing people to appear via Zoom, but you can also appear in person. But you'll go in front of the judge and you'll have a mini hearing where if there has been an objection, is it an objection based on your not being eligible for an expungement or sealing, and then it would more likely than not, assuming the state police or the police jurisdiction or the state's attorney's office is correct, it'd be rejected. Is it more public policy grounds where the state is saying, yeah, they're eligible, judge, but you shouldn't grant this because the record should remain existing because there's a public policy reason to deny this request. And then there are some others again where they being the state doesn't want to have the record sealed or expunged. It feels like more out of spite, and I only laugh because I have no other way of describing it. You have a client who is 100% eligible, the timing is correct, the charge was correct, maybe they weren't even convicted, meaning there was just a charge and they were found not guilty or the case was dismissed. They're like, I want this off my background. I don't want somebody to find that I was arrested for something I was exonerated of, which of course is pretty logical. And I've had the state's object to that, and you actually have to appear and say, well, yes, it's a proper objection, they're allowed to do this, your honor, but don't listen to them. You should still grant our relief and expunge this or seal this record. But that's the process: a petition, notification, blank orders, and then actually appearing in court.
So just two quick questions. You mentioned a payment for this, and then you mentioned 90 days, but there's other things happening before that. So, what is a typical cost? Maybe there's variables there, and give an estimated time frame.
Sure. There's a few fees that are associated with it. And at my firm, we largely work on flat rate retainers and then include everything in that. So when we're looking at doing an expungement or a sealing, it's usually between $2,000 and $3,000 all in. Now that will include some of the filing fees that are associated with this, and then the actual work of, okay, we need to go and find that case number. We need to do the due diligence in finding who the arresting agency was, verifying your eligibility, completing the paperwork that we're talking about, making sure the proper entities are served, and then, of course, appearing in court, reviewing any objections that come in, because every now and then you do get a real kind of nuanced or interesting one where we need to argue. We actually have, there's two sides to this, and the other side's represented by an attorney, be it the Illinois State Police or the Cook County Sheriff's Department or the state's attorney's office itself. They will have an attorney there. And it's like, you should have an attorney there as well. So finally appear in court and make that argument and make sure that the orders are entered correctly as well, because nothing would be worse than go all the way through this process and then the order doesn't actually get entered, and then there's nothing to expunge at that point. It's like it was granted orally, but the order never hit the file. So then these entities don't know to do away with the documents and their files and so forth. And I follow up. In fact, I'm ironically enough looking on my desk right now, and I have one of these documents right now from the village of Schaumburg, in fact, confirming my follow-up that yes, these records have been expunged, they've been deleted. Here's the verification. And that's just an added step that we go through as an attorney to make sure that our clients' records truly are expunged, not that they just think they're done, when in reality, maybe they didn't jump through every hoop they needed to.
So, as we're wrapping up here today, how does clearing a record actually change somebody's life? For example, in employment, housing, or licensing? And what's your advice for somebody who's not sure whether their record can be cleared but wants to find out?
Sure. Well, really huge benefits. If somebody's worried about not being eligible for a lease somewhere because they're going to be rejected for a lease application, or maybe they're looking to get government subsidized housing or something like that, where this conviction is what would cause them to not be eligible, but with an expunged or sealed record, now they are eligible. Now they've just availed themselves of all kinds of government assistance, which can also include, depending on the type of charge, student loans would be an example of that. With certain charges or convictions on your background, you're not eligible for that government assistance. So these can be huge, life altering, in a positive way, benefits to getting your record cleared up. The other most classic example is usually for employment purposes, is that while in Illinois, we actually have a great deal of support for people with criminal backgrounds, meaning you can go through the entire employment application process. You are not required to disclose that you have a criminal background until after you've been offered a job. And then the employer puts the onus on them to verify that, yes, you have a criminal background. Does that criminal background actually foreclose you from doing this job? And if so, then they could withdraw an offer. It gets a little hazy there. But just to be able to say, listen, I don't have a criminal background, offer this job and feel comfortable and confident. That's a really big part of it. And then to answer that ultimate question, am I eligible? There are so many little nuances to all of this. And yes, maybe one charge is eligible, but another one isn't, or you have the wrong type of things in your background. Only an attorney really can answer that. Somebody who actually handles these types of cases and this situation on a daily basis is just reach out to the firm. Be open and honest, provide all the details that and then we can go and double check things and dot I's, cross T's, and confirm whether you're eligible or not. And if you are, or we believe you are, go through the process of completing this paperwork so you can get your record clear and move on with your life.
Beautiful. Well, thank you for joining us on Defending the Windy City with David Drwencke. Clearing your record can open doors that felt permanently closed, but only if you follow the right legal path. To learn more or connect with David and the team at DRD Law, visit drdlawllc.com. And thanks for listening. And remember to like, leave a review, and subscribe to the show so you don't miss the next episode. Thank you, Drew.
Thank you.